powers of judge to discover truth. In this tutorial, we study various powers a judge can exercise in order to discover truth. We all know that we adopted British model of justice system. As such, many believe that the judge has a very minimal role in discovering truth. Moreover, the way our system functions in the present times indicate that judge has a very minimal role. But if we study various provisions under Evidence Act, CRPC and CPC, clearly indicates that judge has a very vital role to play to discover truth. Now, let us turn to the various provisions that are dealt under CRPC, Evidence and Civil Procedure Code. Now, coming to the foremost important provision in this respect, Section 165 Indian Evidence Act. It says the judge to discover proper proof of relevant facts, he has many powers. Number one, he can put any question to the witness at any stage. It can be examination of chief, it can be cross-examination or re-examination. And more interestingly, he can put leading question also. It is also not necessary that it is a relevant or irrelevant question. Furthermore, the judge has such a power to recall any person who is not produced as a witness. Apart from that, if he feels that witnesses who are already examined need to be re-examined, he can summon them as well. Apart from these, the judge has within his power to summon the production of any document, any material whatsoever. If any person violates the directions, he is subjected to sanctions as prescribed under CPC and CRPC. Thus, it is evident from 165, judge is omnipotent to discover, to call out truth in any manner he chooses from the parties on either side or from any person. Now coming to the next power which court can exercise, local inspection. It is provided for a judge both under CPC and CRPC. Under CRPC, it is expressly provided by way of Section 310, whereas under CRPC, under Order 18, Rule 18. The sum and substance of these two provisions are like this. The judge at any stage, in order to discover proper proof of facts, can visit the scene, can go to any place and demand the parties to come to that spot. And it is his duty to record whatever he observed there and finally to make it as a part of the record and make his observation while passing a judgment. Thus, point is the judge to discover truth need not confine himself to the four chambers, four walls. He can travel beyond. That's the theme of Section 310 CRPC and Order 18 Rule 18 of CPC. Now coming to the next provision, demeanor of witness. We all know that it's non-verbal communication which speaks more than verbal communication. Therefore, judge, while recording evidence, he can definitely and certainly record the non-verbal communication made by the witness. This is called a demeanor of witness. That provision is expressly provided by way of Section 280 CRPC and Order 18 Rule 12 of CPC. Coming to the next point, whether judge should remain silent in the absence of production of material by party on either side, the answer is no. The relevant provision under Section 114 of Indian Evidence Act says the court may presume under circumstances like human conduct, public and private business, common course of natural events, despite lack of production of evidence by parties, the court basing on these three criteria can presume certain facts. Thus, judge merely because there is no evidence, he need not remain mute and shall not become a helpless person. Thus, Section 114 empowers judge to presume certain facts. The only rider is he must take into cognizance whether such presumption is backed up by common course of natural events, human conduct, public and private business. And next is seeking information from the accused. This provision is primarily available to a criminal court judge. This is an important stage under criminal law, section 313, wherein upon completion of prosecution evidence, the accused will be explained about the incriminating evidence that is made against him. At that time, without there being any oath, the accused can directly speak to the judge, and judge in the course of their interaction can definitely know many valuable information to find out the truth of the matter. And it is the duty of the judge shall receive whatever the document which he files, and marking is not necessary while he taking any document, making it as a part of record under the 313 examination. And finally, power to add any person as a party to a suit or to try any person as accused. As we are discussing, either CPC or CRPC, the judge merely shall not confine himself to the parties who are arrayed as plaintiff or defendant, prosecution or accused. If the judge feels that some other person is necessary to adjudicate the claim, he can direct that person to join as a plaintiff. If he is unwilling, he can be added as a defendant. Similarly, under CRPC, section 319 says, if any person other than the accused already on record appears to be an accused, the court can certainly call that person to join as an accused. Thus, all these provisions together suggest that judge need not go by the party's version. In search of truth, in search of establishing justice, he has many powers to discover truth. That's the end of the class.